We're going to try to get started for this last afternoon session. Thanks, everybody. So we're going to hear from Bob Adler in just a minute, but before we do, I just wanted to introduce someone who many of you already know, I'm sure, Sarah Krakoff, on our faculty here at Colorado Law School. Sarah was just recently named the Hazel Barnes recipient. That's the highest honor that the University of Colorado gives to any member of our faculty, and Sarah was chosen this year as the Hazel Barnes recipient. And she's not here to talk about that, but she's here to talk about a course that she's teaching in the spring of next semester, and she wanted to share some information with you folks about it. So Sarah, you're on.
Thank you, Mark, and thank you, Doug, for giving me just a few minutes here, and also to Bob for letting me cut into his time, but I promise it will just be for a wee bit, and also to Sean and Alice for organizing this great conference. I asked for a few minutes because this is a group that is interested in water and understands the importance of making sure that we have the best and most committed people going into the field in the future. I teach here at the University of Colorado Law School, as Mark emphasized, and like most professors, I like to think that my research makes a difference and does some good out there in the world, and I hope it does. But also, like most teachers, I know that actually the bigger impact is the impact I have on my students, and learning with them and sending them out in the world to be the next generation of people figuring out problems like groundwater. So to that end, the law school has a rich natural resources and environmental law curriculum, and for many years there's been a field seminar that was started by Charles Wilkinson. Mark has taught it, and so have I, and so has now Alice Madden for the first time, and that usually involves a field trip over spring break, a road trip. I've done it 3 times, driving all over the Colorado Plateau to Navajo Nation and Hopi tribe and out to the Grand Canyon and every which way we can get to in cars. And every time I taught it that way, I thought I could teach this whole class through the prism of the Colorado River and include not only the river and the water allocation issues, but also all the public lands issues. And the field trip would be out of cars and on rafts, rafting the Colorado River through the Grand Canyon. And that sounded crazy, and yet it took 2 years or so. But with a lot of help from a former student, Julia Gorino, we made it happen last year. And so the slides that are showing behind you are from the field trip that was the culmination of this Law of the River seminar that I taught for the first time last spring. I had 17 law students. They studied every aspect of the Law of the River in the broadest sense, right, including the public lands and Indian law issues that surround that canyon. And so the issues they studied were from headwaters to delta, but of course the field trip you could, I guess, still try to do the headwaters to delta on boats, and I know people like Pete McBride have done it, but for the purposes of getting 17 students out alive, I thought just doing Lee's Ferry to the takeout at Diamond Creek would be enough, and so we did that. So after the class and after they took a break for finals, we all drove down to Flagstaff and met with our outfitter, and then drove up and put it in Lee's Ferry and rafted, 14 days through the biggest whitewater in the lower 48, and saw some of the most extreme and beautiful country that you can get to in the lower 48, and did all kinds of side canyon hikes. And along the way, we met with a lot of experts in the class, and also to some extent met with them to and from on the river. And so after we got back with all 17 students, not only alive, but uninjured, and many of them saying, that this trip would change their lives, and I've kept in touch with them, and they're still talking about it and remembering it fondly. I thought, I'll never do that again. That was insane and exhausting. But this year's students heard about it, so they're like, oh, you have to do this again. So we're planning to do the class and the field trip portion again next year, and this is where you come in. This is where I need the help of people beyond the law school in order to make this class available to all students, regardless of their income level or backgrounds. We fundraise to pay for the field trip portion, right? The rafting trip on the Colorado River, so that no law student has to go into debt, because what we hope is a number of them go work for government or nonprofits, and again, to become our natural resources leaders. And so we're starting this, year-long process of trying to raise most of the money so that they can do the class and the trip debt-free. Roger Flynn is going to join me next year. Last year I had 3 alumni, including Alice Madden, join us. And so that's part of the fundraising strategy, is our alums join and pay for their own seat and then help me fundraise for the rest. And so Roger is going to, in a second, walk around with some flyers that we have about the class. And there are 2 ways that if you're interested in this, you can contribute. One is you can just write us a check if you find that compelling. You can also just get in touch with me. My email will be on those flyers if you want more information and just want to learn more about the class and the trip. And then the other way is you can join us. We have 3 more seats in addition to Roger's seat for guest sponsors. And the cost is $4,100 for your own seat. And what we ask of our guest sponsors is that they be willing to pay for at least 1 more student seat. And that portion of which is tax deductible fully. And what you get out of it is you can think of it as sort of those educational trips that some schools do. Like my alma mater sends me these flyers all the time, like go to Portugal with Professor so-and-so, because the students will teach you everything you ever wanted to know about the river on the river trip. They talk about their papers every night after dinner and before they start drinking, and or sometimes after. And when we did it last year, the river guides, these full-time river rats who think they know everything about the river, would huddle around. I mean, they were just so hungry for what my students knew already about that river and its landscape. And so that's an option that's available for you too. If you're interested, take a flyer and get in touch and let me know, and consider joining us. So thank you for these few minutes. Hopefully this has been an enticing advertisement. You can go down the river with these people, or next year's version of them and myself and Roger. And thanks for letting me have these few minutes to do this pitch, and enjoy the rest of the conference.
I'm not going to pass this around, but if you see it outside during the conference, please drop something in. Just passing that around. That's the flyer. Put money in.
I'm sorry.
Yeah, Sean just reminded me that information about the trip is also in your program if you wanted more information about Sarah's trip. Okay, so we're on our last speaker for the day, and Bob Adler comes to us with what is surely the longest title of anybody who's speaking at this conference, and I'll have to read it because I'll forget part of it. He's the Jefferson B. and Rita E. Fordham Presidential Dean and Distinguished Professor of Law at the University of Utah, S.J. Quinney College of Law. Quite a title there, Bob. Yes, that's right. Forget the Stegner Center. You're going to have to do that at another conference. But Bob is also really the preeminent scholar, I would say, in the country on the Clean Water Act. Bob's going to help us shift gears a little bit. We're going to be talking more about Clean Water Act issues and really this fascinating case out of Hawaii. It's not the only case, but it's the one that was featured in your program. This question about discharges into groundwater that may be connected to surface water and whether those are covered under the Clean Water Act. It'll be interesting to hear your perspective on it, Bob. I should mention, by the way, that I studied constitutional law with Jefferson v. Fordham, and I have some great Jefferson Fordham stories, so maybe someday we'll get to talk about it. Anyway, thanks. Welcome.
Thanks very much, Mark. Thank you, Mark and Doug, for inviting me. This is my second year in a row. I thought I was provocative enough about talking about the Colorado River last year that I'd never be invited back. Anne sitting there, she was sitting next to me, kind of looking at me like, whoa, he's going off the deep end here. This subject is inherently a little bit less provocative, but I do want to compete with Sharon for rights to Monty Python quote, and now for something completely different, because we've been talking about groundwater quantity. All day we've heard very little about groundwater quality. Heather's presentation did a good job, I think, of showing that the quality and the quantity side are interconnected, as are groundwater quality and surface water quality, which is what these cases are all about that I'm going to talk about. Quick opening perspectives. This is as much about words as it is about groundwater, as is true for much law and much statutory construction. The learned hand quote was not written about environmental law, of course, but I think it's quite apt, and you'll see that's true by the end. This is one of my favorite quotes from someone I was negotiating against in one of these multi-party facilitated groups. You can write the rest of the statute so long as I get to write the definitions. And that is a truism that I use in teaching my students about complex environmental statutes all the time. And again, by the end, I think you'll see why that's appropriate and relevant. So the question that I have posed it, or as I have posed it, is deceptively narrow. You note that I'm not asking, does the Clean Water Act cover groundwater? Because the answer to that question is unequivocally yes. And many Clean Water Act practitioners would find that surprising. But if you read the two non-point source pollution provisions in the statute, Section 208 and Section 319, and other provisions of the Clean Water Act, Congress talked about groundwater and called upon the states to try to regulate groundwater quality, but just not through the strict enforceable mechanisms that we have on the point source discharge side of the statute. So the question that I'm going to talk about and that these cases talk about is, are pollutant discharges to groundwater regulated by Section 301A of the Clean Water Act, which I'll explain in a minute for those of you who don't know what it is. But it is what I think is the pivotal operative provision in the Clean Water Act in terms of regulating point source discharges of pollution. It's what I call the qualified discharge ban, meaning that discharges to the waters of the United States are banned unless you get a permit under Section 402 or 404 and you comply with the terms of that permit. So Mark said I will be talking about one case out of Hawaii. That's not true. I'm going to talk about 4 cases. I would have talked about only the Maui case if Doug and Mark had agreed to send me and my wife on a site visit there, but they didn't agree to that. More importantly, since the Ninth Circuit case, the Sixth Circuit also ruled on the case, on a related case, and there are 2 district court cases in the Fourth Circuit which decide on either side of the issue, which means that we might have a circuit split, which doesn't, of course, guarantee Supreme Court review, but it increases the likelihood that this issue might get reviewed by the Supreme Court. So I'm going to tell you about the facts of these cases, give you the necessary statutory background, summarize the holdings thus far, and then try to give you my thoughts and perspectives about the importance of the cases and what they mean. So these are the four cases. The Hawaii Wildlife Fund case out of the Ninth Circuit, the Upstate Forever case in the Fourth Circuit, these 2 district court cases, one in Tennessee and one in Kentucky. Interesting to note that all 4 are citizen suit cases, not enforcement cases brought by the government. And just to note, there are a bunch of other cases out there on these issues, but I think I can't possibly talk about all of them, but I think these 4 cases kind of cover the spectrum of the legal arguments and where the courts have been going on this. So, facts of the Maui case. This is the County of Maui's sewage treatment plant, which is on the coast on the northwest corner of Maui, why I wanted a site visit. This is a close-up. Here's the wastewater reclamation facility. You can see it's very close to the ocean. But rather than an ocean outfall or ocean outfalls, which is what the county looked at when it was applying for its MPDS permit, they decided instead to discharge their sewage effluent into wells between the plant and the beach and the ocean. Now, Hawaii is made up of volcanic rock, right? So there's a lot of porous areas in there, and there are connections between the discharge wells and the ocean. So I say admitted hydrologic connection to the Pacific Ocean, and in fact, this case was litigated on a motion for summary judgment because the county did not and could not controvert the facts. They acknowledged that the pollutants that they discharged into these wells, in fact, reached the Pacific Ocean, but they argued that as a matter of law, they were not subject to the NPDES permit requirements of Section 301A. So these are just two slides from a very extensive EPA dye study documenting the hydrologic connection between the wells and the ocean. These are the wells. Here's the sewage treatment plant up here, well 1, 2, 3, and 4. These are seeps. So in our first presentation this morning, you talked about groundwater seeps that actually go into marine systems as well, and these are that kind of seep. This is the dye study, which looked at all sorts of pollutants. This happens to show the increased algal growth in the ocean adjacent to the sewage treatment plant, one of many pieces of evidence documenting that the pollutants, in fact, ended up in the Pacific Ocean. Second case out of Tennessee is a coal-fired electric power plant, which generates fly ash and bottom ash and a lot of other coal residuals, which they store in these ash ponds next to the Cumberland River. Again, there's extensive documented evidence on the record that by storing coal ash in these unlined facilities right next to the river, the pollutants end up in the river. This is a karst geology, again, quite porous and likely to be a conduit for pollutants into the river. This is a modeling study. This is not actual data, but modeling showing the likely nickel concentrations up gradient from the landfill, underneath the landfill, and migrating into the river. And in fact, nickel and other metals and other pollutants are found in the river adjacent to the plant. Kentucky Waterways Alliance case, pretty much a carbon copy of the facts of the Tennessee case. Here's the power plant. This is a closed coal ash pond, again unlined, again adjacent to this channel, which goes into a popular high-quality recreational lake in the state. The active ash treatment ponds are here. Again, there's extensive evidence that the pollutants migrate from the ponds into the surface waters adjacent to the power plant. Final case is a little bit different in a couple of respects. This case in the Sixth Circuit involved a gasoline pipeline which ruptured. The gasoline spilled onto the ground. It was about 1,000 feet from the nearest navigable water, and the documented evidence showed that the gasoline flowed through the groundwater into the surface water. One key procedural difference from this case, or about this case for you Clean Water Act junkies, is that there was a Gwaltney issue. So Gwaltney is a US Supreme Court case from the 1980s that says that in order to plead a citizen suit over which the district courts have jurisdiction, you have to allege an ongoing violation. It can't be a wholly past violation. And so the discharger or the operator of the pipeline fixed the pipeline. So they said there's no longer gasoline spilling from the pipeline, there's no ongoing violation, and therefore the district court has no jurisdiction. The plaintiff said the groundwater is still conveying gasoline into the surface water, so there is still an ongoing discharge of pollutants to a water of the United States. So the procedural context is a little bit different for this case. Okay, so let me give you the necessary statutory background. This is what Section 301 says. Clean Water Act's a 500-page statute, and these are the key words. These are the key words in terms of point source regulation. It says, accepting as in compliance with the permitting and the substantive control, the discharge, effluent limitation control provisions, the discharge of any pollutant by any person shall be unlawful. So this is a perfect case of where what the definition of these words mean is critical. This is the Clean Water Act. So it's clear that we can't take this literally. It doesn't mean a discharge of a pollutant anywhere in the world to any medium is unlawful. It's got to involve water to some degree. So what does discharge of a pollutant mean? So fortunately, Congress did define the term discharge of a pollutant to mean any addition of any pollutant to navigable waters from any point source. None of these cases, in none of these cases is there a factual dispute over the fact that we're dealing with pollutants. And in fact, in none of these cases is there a dispute really that pollutants were in some fashion added to the navigable waters, okay? The word addition is not defined. In the Clean Water Act, there's another whole line of cases that I won't get into about what addition means, but essentially the courts have said addition has to mean that the pollutants come from somewhere in the outside world to the navigable waters. So some of the key cases involved a transfer of pollutants from one water body, say a polluted water body, to a relatively clean water body, and thus far the courts have said that's not an addition of pollutants from the waters of the from outside the waters of the United States to the waters of the United States. There is, however, a definition of navigable waters to mean the waters of the United States. Question, does that include groundwater or not? This is one of Congress's great moves in the 1972 Clean Water Act. They take a definition that the Supreme Court had defined quite well in 4 different legal contexts, so we knew what navigable waters mean, and they replaced it with a completely undefined term that the courts had not addressed, and that is not further defined in the statute except saying that it includes the territorial seas, okay? So that's the definition, and the term point source is defined as meaning any discernible, confined, or discrete conveyance, and then there's a bunch of examples, including a well, like the wells in the Hawaii case. But the definition of point source is there primarily to distinguish it from non-point source pollution. So non-point source pollution is diffuse runoff pollution into water bodies that cannot as readily be permitted or controlled, and which Congress was very clear in 1972 and beyond as a matter of federalism that it wanted to leave to the states. So it wanted non-point source pollution controlled, but it gave a lot more discretion to the states as to how to control it using permitting mechanisms or education or financial mechanisms or whatnot, whereas point source pollution is subject to this very strict permitting requirement. Okay? So 3 key legal issues about whether these discharges in the cases that I outlined to you are subject to the qualified discharge ban in Section 301A. Theory number 1, or you can look at these as 3 potential theories of liability for these discharges to groundwater. One is that maybe groundwater is a water of the United States, which is not defined in the statute. Theory number 2, is groundwater the point source from which these pollutants are discharged or added into the adjacent navigable waters or surface waters of the United States? Or third theory, which I'll heretofore refer to as the Conduit Theory, which is, does 301A impose liability for a discharge from a point source through groundwater into a water of the United States? So if you're more of a visual learner than looking at the words, This is a simple way to conceptualize this. Think about it as like links in a chain. In order to have liability under Section 301A, you need a point source from which there is an addition of pollutants into a water of the United States. Okay? So legal issue number one is, can groundwater be the third link in the chain? Can groundwater be a water of the United States for purposes of Section 301A liability? Issue number two, can groundwater be the first link in the chain? Can groundwater be the point source from which pollutants are added to a water of the United States? And all three of these were litigated in some but not all of these cases. And the third theory is the Conduit Theory, which says, does there need to be a direct addition of pollutants from the point source into the water of the United States, or can it go through groundwater as a conduit to the water of the United States? Okay? So here is the scorecard. Here's how the four cases have decided each of these issues. These are the four cases that I outlined the facts of for you. These are each of those three issues, and here's how each of the courts have addressed those. So, is groundwater a water of the United States? Something about which I'm quite skeptical in terms of the statute and its legislative history. The district court in the Maui case ruled yes. When it got to the Ninth Circuit assumed without deciding that the district court was wrong about that. The Ninth Circuit could assume it without deciding because the district court found liability on a different theory, on the Conduit Theory. For the non-lawyers in the room, courts often try to avoid unnecessary rulings of law. And so the Ninth Circuit said, because we find liability under this theory, we don't need to decide whether groundwater is a water of the United States. In upstate forever, the issue wasn't alleged in the complaint. The plaintiffs didn't allege that groundwater was a water of the United States, so it wasn't addressed. In Tennessee Clean Water Network, the Sixth Circuit implicitly rejected the argument. I would characterize it as dictum, both because of the language that the court used in addressing that issue, but for the same reason that it also found liability on a different ground and did not need to address that issue. The Kentucky Waterways District Court case on appeal to the Sixth Circuit resoundingly rejected the argument that groundwater is a water of the United States. Okay? Second argument is groundwater a point source. Pretty similar pattern on that issue. The district court found yes. Note that the district court in Hawaii Wildlife Fund, I don't know if the judge was a surfer or what, but found liability in all three grounds in the case. The Ninth Circuit, again, assumed without deciding that the district court got that issue wrong, that groundwater is a diffuse medium and not a discrete and defined conveyance of pollutants. The issue was not addressed in either the Fourth Circuit case down below in the district court or in the Court of Appeals or in the Tennessee Clean Water Network case. Again, it was addressed and litigated in the Kentucky case, and the district court found no. Okay, so far, doesn't look so good for 301A liability until you get to the Conduit Theory. And there, we've got an agreement between the two courts of appeals that have ruled on the issue this year, and one of the two district courts in the Fourth Circuit, but not the second. So this gets a little bit interesting for the hydrogeologists in the room as relevant to some of the issues that you were talking about this morning. Okay, so the Ninth Circuit said yes, but only if the pollutant stream can be fairly traceable from the point source through the groundwater into the water of the United States, or only if there is a significant nexus between the groundwater and the surface water. I'll get back to this in a minute. The Fourth Circuit said yes if there's a direct hydrological connection between the groundwater and the surface water. This was a 2-1 decision, by the way, and the dissenting judge in the panel said this is really non-point source pollution under that federalism rationale, and also would have found on the Gwaltney ground there. The Tennessee Clean Water Network case in the Sixth Circuit said if there is a direct and immediate hydrological connection between the groundwater, I'm looking carefully at the hydrogeologists to see their reactions to this, because I think it may be interesting how this plays out, which can also be traced. Okay, and the district court in the Kentucky case said no, Congress intended groundwater to be controlled under the non-point source pollution control provisions, even if there is a hydrologic connection between the groundwater and the surface water. So returning to my little rubric here, the scorecard gives us what looks to be a no on whether groundwater is a water of the United States. Just a footnote, these are cases decided on statutory grounds, not on constitutional grounds. So the courts are not asking, had Congress actually included groundwater in the Clean Water Act, would it have been constitutional to do so? And there are people who would argue that it's not. I've got at least 2 constitutional theories that I could raise that I think it would be constitutional, but we're not there. The courts have ruled on statutory and not on constitutional grounds. Second issue, can the groundwater be a point source? Again, I think we're pretty clearly at a no on that issue. And on the third issue, can groundwater be a conduit? And the answer appears to be, at least the weight of opinion thus far, pending a decision on the 2 cases in the in the Fourth Circuit, if there is a direct hydrological connection which is fairly traceable. Now note that the courts have slightly different tests for liability, right? Because they're making it up, right? None of this is coming directly out of the statute. So there's an analogy to Justice Kennedy's plurality opinion in the Rapanos case, which was a 414 case, but Justice Kennedy's opinion tends to be treated by the lower courts as the controlling opinion, in which he said that isolated wetlands are regulated by the Clean Water Act, by the discharge provisions, if there is a significant nexus between the isolated wetlands and the water of the United States. And he made that up. And I've talked to aquatic ecologists at EPA and elsewhere, and they've said, there is no scientific concept of a significant nexus. We don't talk about, significance. We try to figure out whether there is an ecological connection and what it is, and we try to measure it. And I think the same thing is going on here, because the courts are coming up with words like fairly traceable, direct and immediate hydrologic connections. Some of them come out of EPA guidance. Some of the courts say these tests are the same thing, and some of the courts say that they are different. So we heard about Darcy's Law this morning, right? And the connection is along a continuum, right? It's a function of distance, it's a function of how much impedance there is in the soil, and so forth. So whether or not there's a direct hydrologic connection or a direct and immediate hydrologic connection is something that is going to be, under these cases, the subject of additional litigation. It's going to be full employment for hydrogeologists and consultants, so you can take some comfort in that, but it's not entirely clear. The Tennessee court found both you need a direct connection, which is fairly traceable, okay? So let me give you some perspectives. The first perspective is going to be a statutory interpretation one. And by the way, the arguments in this case were quite complicated. There are a whole bunch of arguments that I don't have time to review. I'm trying to give you kind of the crux of the case. But what's interesting about the statutory interpretation issues is that both sides accuse the other of improperly imputing words into the statute that aren't there, okay, but different words. So the courts that have found in favor of the conduit theory have argued that a more restrictive view would improperly add the word directly into the statute. What the statute says is any addition of any pollutant to navigable waters from any point source. It doesn't say directly. Interestingly, Justice Scalia, in his majority, well, plurality four-person vote opinion in Rapano, said you don't need a direct connection. And so even though Rapanos narrowed the scope of the Clean Water Act, these courts are using Justice Scalia's reasoning to expand the scope of the Clean Water Act in these cases. Okay, flip it over, and the courts that rule against the conduit theory say, well, it can't be that any addition of any pollutant to any groundwater is covered, even if it will take 1,000 years to get for those pollutants to get into the surface water. So in order to make the theory viable, the courts have had to make up these tests to add language to the Clean Water Act that isn't there. And that ignores the syllogism in the statutory language, which is simple and elegant. It's got to be any addition of a pollutant to navigable waters from any point source, period. But of course, that brings you full circle around to the question of whether that means directly into a navigable water. So legitimate statutory construction arguments on both sides of the case. So let's look at it from a policy perspective. The courts that, and the parties who argue against liability here basically cite this federalism rationale that Congress very intentionally distinguished between groundwater and surface water and between non-point source pollution and point source pollution. And by finding liability here, the courts are ignoring those distinctions and ignoring the federalism policy that Congress articulated, which Congress said it did because it wanted states to have control over land use type pollution, which was more appropriate for state and local control. So improperly intrudes on legislative distinctions and policy choices. The flip side of the policy argument is if you allow someone to avoid the discharge ban in Section 301A by simply discharging the pollutant right next to the water body onto the groundwater, it is the biggest loophole you could possibly think of. If you simply have to discharge the pollutants into the wells, which you know are right next to the water body, that's a huge loophole. If you can simply discharge it onto sand next to a river where you know it's going to get into the water body, we can't allow such a loophole. So again, there's policy arguments on both sides of the coin. Okay, alternative case, take on the case. And I know this is heresy for a groundwater conference, but my question is, are these cases even about groundwater per se, or are they about the conduit theory? So the courts that found in favor of the conduit theory in the groundwater context cited earlier cases that had nothing to do with groundwater. So let me give you a few of them, not all of them. So one is the Concerned Area Residents for the Environment against Southview Farms, a case out of the Second Circuit involving manure spraying onto a field in which the manure from the field ran off into the navigable water. And the court found liability, finding that the manure sprayer is the point source from which there was an addition of pollutants through the field into a water of the United States. So the field was the conduit, and the court said it doesn't need to be a direct discharge. This is the same thing as if the manure went directly into the navigable water. Okay? Case number two, Headwaters versus Talent Irrigation District in the Ninth Circuit, of relevance to people out here in the West where we've got a lot of irrigation canals. pesticides sprayed from a sprayer onto the fields, which went into irrigation ditches, which are not waters of the United States in and of themselves, but they flow into waters of the United States. And the Ninth Circuit said, this is an addition of pollutants from a point source through the irrigation canals into a water of the United States. You can't avoid the NPDES requirement, the requirements of Section 301A, simply by having the conduit of the irrigation ditch. Third case, also out of the Second Circuit, was helicopter spraying. This was to control West Nile virus in the Long Island Sound area, but the discharge went from the point source, which was the helicopter sprayer, into the atmosphere, into the air, from which it ended up into Peconic Bay and various streams. Again, you had a discharge from a point source, adding pollutants through the conduit of the atmosphere into the waters of the United States. So an argument can be made that these cases are really no different conceptually. We've got three types of point sources. We've got a broken pipe, a well, or a series of wells, and ash ponds, from which water is added into a water of the United States through the conduit of the groundwater. And so long as you can show that connection, there is liability under Section 301A. And the courts aren't saying that groundwater is the target of regulation. They're not saying that the purpose of the Clean Water Act is to protect groundwater from discharges. It is still to protect the waters of the United States, whether the pollutants get there through groundwater or not. And that's an important distinction, because the permits that are subject to Section 402 permits have effluent limitations based on technology-based controls and based on water quality controls. Do you apply the surface water standards in writing the effluent limitations, or do you apply groundwater standards? And the difference between these two interpretations is significant in how you interpret these cases. So just a closing perspective, another great quote from Thomas Jefferson, use one word if you can, not two. And this is my commentary on what Congress did in the Clean Water Act, one of many commentaries. In defining the focus of the Clean Water Act, Congress used at least 4 different terms, right? I mean, how to be more confusing, I can't imagine. So the definition of pollution is the man-made or man-induced alteration of the chemical, physical, biological, or radiological integrity of water. Just water. All water, okay? The opening objective of the Clean Water Act is to restore and maintain the chemical, physical, and biological integrity of the nation's waters, which is clearly different from water. The nation's waters then gets defined as navigable waters in the definition of discharge, which then gets redefined as waters of the United States. So we are approaching the 50th anniversary of the 1972 law in 2022, and we still lack certainty about the most fundamental issue, which is what the target of the statute is. What is the set of water bodies that Congress intended to regulate, and in what ways? And on that very happy note, I will leave you so we can answer questions.
Thanks, Bob. That was terrific. I think we're going to have a little discussion now and questions and answers, and I'm going to call the panelists to come up maybe to the front, and we can maybe just have a little discussion there. Heather, I know, had to step out, and I think she's coming back. She's back. Okay, good. So she's back, and she'll be able to join us too. So that's great. And I'm just going to start. Do we have the little microphones? Okay, we're going to pass them around. So while you're thinking about your questions, I guess I'll just pose one to Bob since he just finished, particularly with his last slide about all of the definitional issues that we still haven't resolved under the Clean Water Act. Obviously, we're still in the process of trying to figure out how the EPA and the Corps should define the term. But I guess a related problem, which has troubled me, I guess, from the beginning, is just the choice to use the phrase navigable waters at all, when it's pretty clear that Congress didn't actually, it's clear to me, it's apparently not clear to the Supreme Court, but it's clear to me that Congress did not mean navigable waters, at least if you believe the legislative history of the Clean Water Act. And I guess any thoughts or perspective on the choice of that phrase? Because, I mean, one of the interesting things I think about using the phrase navigable waters is that Congress defines it, as you point out, as waters of the United States, but Justice Kennedy in particular refuses to interpret that phrase, but instead goes back and interprets the phrase that Congress defined, that is navigable waters, which leads him down this path of trying to show this significant nexus problem. And I guess the thing that frustrates me is that the Congress chose to even employ that phrase when it didn't, I don't think it meant what we conventionally think of as navigable waters, recognizing that it means lots of different things depending on the context. Anyway.
So if you're frustrated, join the club.
Yeah.
And you're right, Justice Kennedy declined to give significance to the word, but Chief Justice Rehnquist manifestly did in the Swank case, the previous case in which the Supreme Court had addressed this issue. And he said, even though Congress redefined navigable waters as waters of the United States, they didn't eliminate the term entirely, so the court has to give it some significance. As to why it happened, I have one word: politics.
Yeah.
Right? And in 1972, or 71, a couple of things were going on. One was that Congress was building on the prior water pollution control regime in the Rivers and Harbors Act of 1899, which was based on the Corps' traditional authority over navigable waters. Now, this, by the way, is the broader Supreme Court definition of navigable waters under U.S. v. Appalachian Electric Power, which is not only waters that are navigable in fact, but any waters the use and effect of which might affect navigable waters. So upstream tributaries and adjacent wetlands and so forth are fair game. So that was one thing that was going on. The other was the tussle between the House and the Senate would have rejected the concept of navigability entirely, I think, and the House didn't want to, and they wanted to get a bill passed. So this convoluted set of definitions, I think, was an artifact of just political arm wrestling. It's my theory.
Fair enough.
I'll say I was always confused by navigability until I got to see firsthand Bob Adler's chapter on navigability in our book, which is the first time I've been able to understand it and teach it. Because the only way I think students and other practitioners get their head around it is you have to recognize the historical lineage of it, the different usages of it, and it needs a clear guide. And frankly, I think you contribute to that.
Okay, thanks. All right, let's hear from the audience. Yes.
Again, Bob, the last talk, you talked about conduits. And in groundwater, pollutants can be transformed both chemically and biologically. And as we know in our personal lives, sometimes the daughter products are worse than the parents. And so I was wondering if this transformation affected the way the law interpreted this conduit idea at all, the fact that a pollutant can actually change form into something that's worse or not as bad.
I don't think so. I don't think it would affect the court's analysis. In all these addition cases, I know of no case in which a court has said the pollutant that enters the navigable water is different, a byproduct pollutant or something, than the pollutant that was discharged from the point source, and therefore it no longer counts. I think the court would only look at whether a pollutant is added to the navigable water as a result of the discharge. But I can't cite you a case on that. I'm not sure it's been litigated. Do you? Anyone else know? No?
Way in the back, yeah.
We're from India and we do So we do interstate water dispute resolution cases there in India. And recently the Supreme Court in India decided a case which had been pending for a very, very long time. Actually, the history of the case started in 1892 when there was an agreement between the British government and the local ruler. So, and finally, in the February of this year, the court decided the case. And while deciding the case, for the first time, the Supreme Court took into account the availability of groundwater as a resource, additional resource, while allocating waters between the two states. Actually, there are 4 states. So we want to know, is there... Sorry. So we want to know, is there any case here where the groundwater was reckoned as a resource while reckoning the resource of the basin, and allocation was done while taking into account the availability of water resource? That's one. And 2, for NOAA, I would like to point out that in our legislation, the jurisdiction of the tribunal, which is basically an extension of the Supreme Court, arises only when there is a prejudicial affectation. The word used is prejudicial affectation. And when doing the adjudication, we obviously look at the US and we refer to all the cases that has been decided by the US Supreme Court. But the trigger is prejudicial affectation. In fact, my friend argued the case which was just decided. The trigger there was again prejudicial affectation, and whether the usage amounts to prejudicially affecting the other side. So, you're just taking off from what you said. But is there any case here in groundwater? Because I thought that was a path breaking, and we were on the side who argued that groundwater should be taken into account, and it took into account 20 TMC of water, which is about 5% of the total water which was assessed in the basin as available water resource. So is there any case? I mean,
I'll take a shot at it, but first of all, it's a great question, and obviously, in this area of law, comparative law is tremendously important. The U.S. it's one of the few areas where the U.S. Supreme Court has acknowledged that it both borrows and lends law from other jurisdictions. I am not familiar. First of all, my understanding would be that under equitable apportionment law in the U.S., there should be room for a party to argue or for a court to consider the availability of groundwater to the parties in reaching an equitable apportionment of a surface water. That is fair game in the list of equitable apportionment factors, but I don't think a court has ever done so. And if anything, the current controversy over the Apalachicola Chattahoochee Flint would be a great opportunity to do that. Georgia does have groundwater available to it that would allow it to meet some of its water needs without destroying the ecosystem downstream and the oyster fishery and that. But I think we're behind you, essentially. I don't think we're behind you doctrinally. I just don't think our courts or parties have teed it up. Is that right? Yeah.
Yeah, so I'm not sure that if this directly answers your question. It brought to mind Heather's discussion about what they were doing on the reservation on the Agua Caliente, because clearly the main resource that you're dealing with there is groundwater resource. Without the groundwater, there's not enough water for the tribe, and so certainly recognizing the importance of groundwater in that context becomes really important. The one case I might cite to you that I'm not sure if this is directly on point, but it's a really interesting case, I think, and it involves the situation that was talked about this morning in the San Luis Valley in southern Colorado, where the groundwater resource is so plentiful and the surface water resource so problematic, not in the same way as Agua Caliente, but problematic in the sense that groundwater users easily interfere with surface water, and under our prior appropriation system, that was messing everything up because the surface water users were forcing curtailment of groundwater appropriations. And so what the court did, which I thought was a really interesting solution to the problem, it forced everybody to move to groundwater. And this was upheld. Actually, it was the state that forced it, and the court upheld it. So the recognition was that the groundwater resource was a better place to be allocating water, and people who had historically had their water rights from the surface were not going to lose their water rights, but they had to shift their point of diversion to a groundwater well, and then there was enough water for everybody. And just an interesting way to sort of recognize the integration of water and surface and groundwater. Yeah, I'll be sure that you get it.
You had a hand up over there, sorry.
Go ahead, Noah, you want to help me here?
I saw a hand.
There's a hand over here, but was there one over here?
Yeah.
Yeah, go ahead, okay.
Is there a case where we can trace navigable water back to the point source? Or is that a dumb question and that's
So you mean to identify a previously unpermitted point source?
having trouble finding if it's dispersed so much from the point source to the navigable water.
Yeah.
Do the reverse and trace it somehow back to the point source.
It would be kind of, kind of groundwater forensics you'd have to do. In all these cases, the sources were known, and so they didn't have to do that. The whole reason Congress moved from a water quality focused approach to a point source control approach in 1972 was the difficulty of tracing pollution from the waterway back to the source. So they started controlling sources at the source. There's no reason why one couldn't do that if one could scientifically, conclusively demonstrate that someone was discharging a pollutant from a point source that ended up somewhere in a navigable water. Those just weren't the facts of these cases.
There was a question here, yeah?
Yeah, this is again for Bob. I've been very engaged in this NPDES issue for the last few years, both with EPA and now with the National Groundwater Association. And I want to just ask your thinking on another issue around this. The conduit thing, I think, is right on. And that, in my practice, that's where I was always at when asked to advise on that. The question gets to the point of compliance. If you have effluent limitations, the point of compliance for the pipe is at the end of the pipe, directly into the navigable waters, or I like to say jurisdictional waters. But if you're discharging to a pond, which then goes to the stream, as I understand it, under the current law, the point of compliance is at the stream. And that's incredibly problematic and difficult to do. So am I right about that, or is the point of compliance, as it should be, where it is discharged to the pond?
So remember that once the NPDES permitting requirement is triggered, there's two types of effluent limitations. There's technology-based effluent limitations, the best technology treatment requirements, which apply irrespective of whether you're discharging into the Pacific Ocean or a tiny little creek, right? So those end-of-pipe effluent limitations should not change whether you're discharging into a groundwater or directly into a surface water. The second type is the water quality-based effluent limitations, where you do need to model back from receiving water quality to the discharge. And it's hard enough for surface water. People use mixing zones to try to figure out where the zone of complete mixing is, so that the compliance point is actually at the edge of the mixing zone and not at the edge of the pipe. For groundwater, you're right. That will generate all sorts of technical questions about how much the pollutant is diluted in the groundwater, does it change in the groundwater, and what's the impact on receiving water quality. Those are technical. Mixed questions of engineering, hydrogeology, hydrochemistry, geochemistry, I guess, and law.
So it's my fault.
Yeah.
But just to be clear, Bob, the water quality standards we all agree that the water quality standards do not apply to the groundwater itself, or do we not agree about that?
If the theory of liability is the conduit theory,
Right.
then I think it's the in-stream water quality standards.
Right, the surface stream.
Right.
Right.
If a court thinks that groundwater is the
Right.
water of the
Fair
United
enough.
States, then in theory, I suppose you could apply groundwater
But no state has
standards.
set water quality standards for groundwater, right?
No, there's
That's fair
Safe
to say?
Drinking Water Act standards,
Right,
blah,
okay.
blah, blah.
Good, okay. Just wanted to be clear on that. All right, other comments, questions? Sean, do you have somebody?
I have a question.
Go ahead.
Yeah, I'm Mohan Katarki. I'm a lawyer from India. I got a question, which in fact Mr. Mark tried to answer to Mr. No. I want a clarity. When you say that the U.S. Supreme Court can better deal with the interstate disputes as a interstate nuisance case than going in for an equitable apportionment. This question has been bogging the Indian courts also for a long time. This is a question like whether egg came first or chicken came first, because we have not been able to really understand how to deal with. Initially, the US Supreme Court, if I am right, dealt it as an injunction suit. And later, first time in the Laramie case, an equitable apportionment decree was entered. But even to deal a case as an injunction suit or a nuisance, a plaintiff has to establish a right. And how will he establish a right unless there is an equitable apportionment? Therefore, in my view, I think so, that equitable apportionment becomes entirely necessary before a question of injunction, whether there is a nuisance or not, to be addressed. Right. So it is advisable that, as Indian courts have taken a view in Krishna water disputes and Kaveri and other things, that all right, you file a complaint of prejudice and fine, but ultimately to address the prejudice, we'll have to determine, we have to resort to the equitable apportionment and determine the rights of the states, that is like limits of actions. So that will be an answer to the entire question of nuisance or whatever the right. Am I right? I would like to just know from you.
Sure.
It's okay, so Noah, our dispute is on the table.
No, I don't, without getting into this, one thing I think I clear up just objectively as a matter of precedent. The U.S. Supreme Court, we do not, it's a fair distinction, but the United States and the Supreme Court very much keeps them separate. It is not a chicken and egg problem. You do not need to have an equitable apportionment to give rise to a nuisance. For example, Wisconsin versus Illinois, the famous Great Lakes case, which is actually 8 cases or something. And similarly, we even do interstate nuisance over air pollution. The answer is, and this does go back to the debate, I guess, with Mark, is that a state can have a right, or to put it even more generally, the state's citizens can have a right, and the state can have a quasi-sovereign and pars patria interest without having a specific property interest or a water right determined by equitable apportionment, simply based on harm. So that the interstate a state has standing to bring an interstate nuisance claim if its citizens or the state's even general interests, quasi-sovereign interests, have been harmed. So you could bring an interstate nuisance, for example, without any physical contact or physical injury. You could have an interstate nuisance claim over non-tangible resources, and you could certainly have an interstate nuisance claim over a state's interest in the Great Lakes or its interest in a water body that is, you might think of either less or more than a quantitative or apportionment interest. And the reason that I think this is, one of the many reasons I think this is very important is that as Great Lakes lessons teach us, a state and its people's interest in a water is often far greater and more complex than any specific quantity of water. The state, for example, might have an interest in the health of a waterway for environmental reasons, for secondary economic reasons, simply because the state decides in its sovereign interest that it wants clean air and clean water for its people. And it does not need to be a property right. In fact, I think we minimize it by calling a property right or limiting it to equitable apportionment.
So I'm going to have to respond to that, Noah. And I'm going to mostly agree, I think, with you in asking the question. I think that nuisance law can provide a backstop. If somebody's being harmed by pollution or by extractions of water that are harming a resource, that can be a backstop there. But relying on nuisance law basically says to us that we have to wait until we suffer harm, maybe even serious harm, before we're going to let the courts address the problem. And I think most of what we've learned, I would say mostly here in the West, I think the East is learning some of these issues, is that you really do need to manage your water resources proactively. And it's not to say we do it right all the time. I've been a critic of much of Western water law, but there is at least an opportunity when you're proactively managing the water to sort of address these things. Now, regarding the water right issue, regarding the water rights and the equitable apportionment issue, what I was trying to say in my quick comment after Noah's talk was that it's really important that we think about how we define water rights through an equitable apportionment. Yeah. Because if we just do it in some quantified way where there's a lot of uncertainty, particularly in an era of climate change when water levels are constantly changing, that's fraught with long-term problems, even short-term problems, most likely. But there are ways to think about an allocation of water that is done based upon a cap or some kind of limit on the amount of water that you're going to allow to be extracted from a resource in order to preserve the health of the resource, for example. And then what's left, what we've decided is available for use, can be allocated through a kind of percentage allocation system. And so it's really important for us to think through how the allocation goes. And in that sense, I want to be really careful about how I'm defining somebody's water rights, but that's not to say that it's a bad idea. And I don't normally think of myself as a strong market person willing to, try to allow economic solutions to all this. But in this particular case, I think it's really important that people have defined rights, even if they're flexible, malleable based upon the amount of water that's available in any given year. So there's my...
Let me pile on Noah's side here a little bit. Okay. And I'm just going to throw this out as food for thought. I'm new to this fun argument that's decades old. First of all, when you have an interstate compact, the reason you have an interstate compact is to avoid the court doing it for you, okay? So a compact equitably allocates the water, full stop. That's the equitable allocation. No matter how stupid the compact, the court is not going to rewrite that, okay? If equitable allocation has to be done in order to defend your rights, and when those rights are threatened, then you would expect the defenders of those rights to act in defense of them. But what you see in the history of interstate water disputes, you think lag depletions with groundwater. Let's talk about lag depletions with litigation. Okay, the Ark River Compact is signed in 1949. Colorado is basically out of compliance from the day that compact is signed going forward. Okay, Kansas sits on its rights, doesn't sue until 1985, and one of the big fights in that case is, do you have liability back to 49 or do you have it back to 86? Colorado wants 86, Kansas wants 49, the court says 68. That's when you should have known, Colorado, okay? So if the equitable allocation is so great, why did it take Texas so long to sue on the Pecos? Et cetera, et cetera. So I'm just throwing that out there. And the argument, I think, is that a state litigant is going to be less efficient than a private litigant. But still, you would expect if your irrigators are suffering, they have enough political power to convince the state to bring suit.
All right, there's a question here. Mike, did you have a question?
It's more of an observation. One of the problems with what you're saying is that most of the compacts around the world, not just in the United States, were written in circumstances and times that no longer exist. And the people who were drafting them didn't do it. The merit of having shares, and they were invented and were turned into limited liability shares in the 1852, I think it was. The power of that way to define an equitable interest in a company rapidly went right around the world in about 30 nations, almost within about 10 years, and is now used everywhere because it's a brilliant way of managing uncertainty. One of the warnings I just want to put on the table is you must never ever define the shares as percentage shares. A couple of places where it's been done, there's a very good reason why you use unit share structures, because then you can adjust boundaries.
I look forward to redrafting these compacts with your help. I mean, the problem is these are federal statutes. So, you know, there are all sorts of really smart things we could do. We should make, there should be a mechanism by which we can adjust a compact more, without the sort of legislative heavy lifting that would require. I concede your technocratic criticisms completely because I'm ignorant about most of them.
That's the point I'm really trying to get across.
Yeah.
Australia, right through the drought, decided to tear up its entire...
And you don't have a Fifth Amendment to the Constitution. It's like a physics problem in high school. There's no friction. Okay? We've got the Fifth Amendment. It's a bitch.
Think more innovatively.
Okay, I'm all ears.
And I think, you know, part of it is you do the taking and then you put something back that's a greater value.
Well,
And they will pay you the compensation and there's no compensation.
Right. No,
Okay, when they send you check.
in fairness, I disagree a little bit. I think if we had the political will,
yes,
we actually could. I'm not a fan of the Fifth Amendment, some parts of the Fifth Amendment either, but frankly, between navigability, public trust, federal navigation servitude, not to mention the wiggle room left under the uncertainty of water law state by state. Many of us, I think, right in the line here, have argued that our governments have far more power to change how we manage water resource with changing conditions than we currently exercise politically. And the legal holdups are more cultural than a strict lock on the courtroom door. Does that make sense?
Yeah. And if you look at the successful transformational reforms around the world, what has always happened was that somebody sat down and worked out how to do it, and then they were ready to go, and the opportunity came politically. It normally happened within days. The classic example of this is in Australia. We tolerated guns like you guys stupidly do. Very smart group of people worked out how to do a compulsory gun ban, gun buyback program, and how you melt all the guns down. At the time, our Prime Minister, like your President, read it and said, impossible. And it was put to one side, but it was ready to go. There was a massive shooting actually in Tasmania. It was a national crisis, and the Prime Minister said, enough is enough, we're doing it tomorrow. He flew in all the governors and said, we're going to do it, aren't we? And the governors said yes. And the equivalent of the National Rifles Association was caught flat-footed. It was all over, done deal. So over the next 6 months, all the guns in Australia were brought up and melted down. Compulsory acquisition. Done.
Well, I'm not optimistic about our ability, whatever our political will to do. Not that it's not a good idea, but we have a different culture here that has been more problematic maybe than Australia. But all right, I think we're at a good point to close this session. Why don't we thank the panel though for the discussion, and we'll look forward to continuing it.